Brief questions. Brief question. You say you do not ask for a particular length of a custodial sentence. Does that mean that you're asking for a custodial sentence?
Yes.
Yes. Thank you. That's being clarified. I think that the defense is ready to make sentencing submissions. Now, earlier, Mr. Canavas, there was an issue of calling a character witness. Could you inform the Chamber whether you still intend to call a character witness?
Regrettably, he's unavailable at this time. He had to return because of Hurricane Irene.
Yes, which then, of course, the question remains whether under those circumstances you would like us to adjourn so as to give you an opportunity to. You want to proceed? Yes.
I did have contact with the witness, and it was a decision that we had made, and it was made with Mr. Kabashi. In fact, I took instructions from Mr. Kabashi on that matter.
Yes.
Regrettably, he's not here. Although, in the meantime, we did receive a report
Could I just? I don't know whether you are about to start with your sentencing submissions. If you are at that point, I'd like to invite you to clearly indicate if there's any factual matter on which you disagree with the prosecution, and to refrain from repeating them to the extent you do not disagree. And further, I would also invite you to clearly keep in mind the discussion before and the final result of that is about the mens rea of contempt. That has been now clearly established where we are in that respect. Apart from that, unless there are any other wishes or comments, you may proceed.
Thank you, Mr. President. Had I any objections to the facts as outlined by the prosecution, I would have already made that clear on the record. I think it's an accurate and fair representation of the facts, Your Honor. I would have put the accent or focus on some other matters, but
that goes without
that's why
saying.
I'm on the defense.
Yes.
I trust Your Honors have received the report from Dr. Falke based on the psychiatric evaluation that was done with Mr. Kabashi at the UNDU. It is brief, and regrettably, we didn't have time to arrange for the psychiatrist to come here, and Dr. Falke does summarize it, but basically the end result of this entire evaluation is that Mr. Kabashi suffers from post-traumatic stress disorder, and I think that's something that needs to be taken into consideration. It is our position, Your Honor, that Mr. Kabashi should serve no more time than what he has already served. Effectively, if you consider good time, he would have served 3 weeks. He's been incarcerated now for 2 weeks at the UNDU. And so when considering that one would, with good behavior, the 1/3, we would argue that effectively he has served 3 weeks. However, when you look at Mr. Kabashi as an individual, his background, his experience, and the fact that he does suffer from post-traumatic stress disorder as a result of being a prisoner of war where he was tortured, where at night he would be woken up to be beaten, where now he is segregated at the UNDU and on suicide watch and woken up every 30 minutes in the middle of the night to make sure that he's alive. That, I suggest, Your Honors, amounts to a much more severe sentence than 3 weeks. I would suggest that we're talking months, the experience that Mr. Kabashi has undergone, even in those 2 brief weeks that he's been at the UNDU. Mr. Kabashi left New York to come and testify here, knowing full well that upon arrival he would be arrested.
1 second, please. Please proceed, Mr. Canavas.
Mr. Kabashi left New York to come here and to try to testify in the Haradinai case, knowing full well that there was an arrest warrant and that he would be arrested on site and that he would be taken to the UNDU. Prior to arriving here, he had met with the Office of the Prosecution in New York. I was present. In fact, he met with him twice. It was explained to him exactly what they wanted to do. He knew that no promises were being made, that irrespective of his testimony, no matter how glowing the testimony would be and pleasing to the ears of the prosecution, that there was no guarantee and certainly no assurances were ever made that the contempt charges would be purged. And I want to make that very, very clear on the record. He nonetheless voluntarily came, even though he did have an option, and the option was to fight it. Before somebody is transferred here on a summons, one does have the ability and the right to challenge it in the courts. And at least from my experience, I'm convinced that had Mr. Kabashi chosen to challenge this, given his the fact that he has been evaluated to have post-traumatic stress, and had he chosen to take that option to fight it, more likely than not, a judge would not have signed off on him to be extradited to testify, knowing that he would be put in prison and knowing that he would suffer in the manner in which he is suffering right now as a result of having that ordeal of 3.5 years as a prisoner of war. When Mr. Kabashi left, his son was 2 weeks old. He left his son, his 3 daughters, and his wife, and he came to testify, knowing that he would have to face these particular charges, and knowing that the possibility existed, a real possibility existed, that he would be spending some time in prison. Now, there's often this debate of whether the judges should fit the punishment to the offender, or whether they should fit the punishment to the crime. This is more of an academic debate. If we look at the statute, Article 24.2 seems to approach it from both angles. It reads, in imposing the sentence, the trial chamber should take into account such factors as the gravity of the offense and the individual circumstances of the convicted person. And unlike in the United States, in the federal courts, where at one point we had these sentencing guidelines where effectively it took away any discretion from the judges, where they just looked at a grid and said, okay, this is the crime, this is the time. Here, the judges do have the discretion. Unfortunately, the statute doesn't provide the sort of guidelines that one might find in national jurisdictions, the sort of guidelines that a judge would look at in framing a particular sentence. And so just for the sake of this particular hearing, because like Ms. Corner, I too am a novice at pleading people out here in this particular court, although I pled out hundreds, if not thousands, of individuals in my previous life in the United States as a public defender. In my particular jurisdiction, here are the sort of factors that a judge looks at. And I'm speaking about the state of Alaska, where I used to practice. 1, the seriousness of the accused's present offense in relation to other offenses. 2, the prior criminal history of the accused and the likelihood of rehabilitation. 3, the need to confine the accused to prevent further harm to the public. 4, the circumstances of the offense and the extent to which the offense harmed the victim or endangered the public safety or order. 5, the effect of the sentence to be imposed in deterring the accused or other members of society from future criminal conduct. 6, the effect of the sentence to be imposed as a community condemnation of the criminal act and as a reaffirmation of societal norms. And finally, the restoration of the victim and the community. In this particular case, and in cases where we're dealing with contempt, I would venture to say that deterrence is perhaps the one that is most important. Certainly not retribution, but deterrence. And deterrence in what sense? I think the charge of contempt obviously is rather significant, because otherwise courts can't function if witnesses or individuals behave as they will in courts. And of course the prosecution perhaps chose not to drop the charges, even though Mr. Kabashi came and tried his best to testify in the Haradinaj case, because they certainly didn't want to leave a legacy behind that one can be in contempt and then it would simply go away. Not that they want to send a message, but they certainly want to make sure that there is some sort of a deterrent factor. But as you well know, Your Honors, sentencing needs to be individualized. And so we have to look at the individual himself. And who is this individual? Now, I've read a little bit from the transcript. I just want to point out one more passage, because I think the message we all have already, as far as what happened and what are and how we arrived over here. But on page 5,439 of the Haradinaj case, back on 5 June 2007, Mr. Kabashi says, Your Honor, but it is not a matter of fear. But then he goes on, I'm disappointed. And not only disappointed, but certain things that should not happen and should not be done in modern world have happened. You yourselves may not have come across such things, but there were persons who were asked questions as witnesses and whose names don't even appear on witness lists because they have been killed. I don't want protective measures, because such measures do not exist in reality. They only exist within the boundaries of this courtroom, not outside it. I leave it to Your Honors to read between the lines of this, considering the circumstances and the charges in the Haradinaj case, and of course some of the comments that were made in the transcript itself, in the judgment itself, as far as some of the shortcomings with the evidence in that particular case. Whether the prosecutor threatened Mr. Kabashi or not, I would suggest that it is often the case where a prosecutor may advise a witness that they have to tell the truth, otherwise they may be held, they may be charged with perjury, and depending on how it comes across. And anyone who would know Prosecutor Ray at the time, I think he at times lacked bedside manners, perhaps may have conveyed it in such a way that was taken as a threat. Maybe that was not his intention, but that's how it was perceived by Mr. Kabashi, especially after Mr. Kabashi had done so much to assist in exposing crimes that had been committed. Now, who is Mr. Kabashi? Well, as Ms. Corner indicated, he had joined the KLA, he has been imprisoned, and he did provide information very early on, as I've indicated, to the Kosovar authorities, to UMWIC, and to the ICTY investigators. Perhaps, and this is something that we come across quite often, perhaps his expectations were somewhat unrealistic, or perhaps unattainable, that things would happen much quicker, that everybody would be arrested that he pointed out to, or that investigations would be done as he had wished, and that the events in the camp, in the Dubrava prison, where there was that massacre, that also would be investigated and prosecuted properly. Perhaps those expectations were overly high and they were not met. And now that feeds into this complex situation which we find ourselves. There's some fear, there's PTSD, there's disappointment. But the bottom line is, this is the same individual who also testified and gave a statement to the effect that when he was a KLA and was given a direct order to go someplace and execute somebody, he went to that place and warned the individual that he was there to do the execution, that the individual should leave. This is who Mr. Kabashi is. He's a man of character. Now, over the past 3 weeks, because this case has literally consumed me for the last, I would say, month, actually. 3 weeks here in The Hague and 1 week in the U.S. Though I had known Mr. Kabashi earlier, I really didn't spend much time. And during the preparation and while he was getting ready to testify, I urged Mr. Kabashi to go in the court and to just answer the questions. And the constant refrain was, you just don't understand what I'm feeling when I walk into that courtroom. You cannot possibly understand. And of course, arrogant as I was, would respond, yes, I do. But how is it possible that I could understand what goes on into Mr. Kabashi's mind and how he's feeling and what reactions he's going to have when I, in fact, have not walked in his shoes? And I was preparing for these submissions. I was reminded of that classic line from the movie To Kill a Mockingbird. You have this wonderful defense lawyer, Atticus Finch, who talks to his daughter. And in that case, she's asking him some questions about the accused. And he says, you never really understand a person until you consider things from his point of view, until you climb into his skin and walk around it. Well, I've tried. The simple principle of wisdom from Atticus Finch reflects, in my opinion, an uncomplicated manner, a principle by which Your Honor should be guided in sentencing Mr. Kabashi. I have struggled with limited success, I might say, to put this principle in practice while representing Mr. Kabashi. You, however, are much more wiser and experienced, and I'm sure you will succeed where I have failed. Mr. Kabashi is 35 years old. He's a child. He comes of a big family, one of 7 children. He has 2 brothers in the United States, a sister, 2 sisters in Europe, and as I've indicated, 2 sisters living in Kosovo, one with 6 children, the other one with 2, and his parents. He's tried to. He went to the United States on asylum, and he's trying to start his life all over again. His brother was here to give evidence, and had he been here, he would have testified as to how Mr. Kabashi struggles today to even describe the events that he went through, both as a KLA and while he was in prison. And I think now they do understand that he does need to be evaluated properly and treated properly. In closing, I just want to say one thing, Your Honors. And I've been practicing law for close to 30 years, mostly as a public defender, federal defender, defense lawyer. And it's been a humbling experience. Mr. Kabashi has character. Give him a sentence that allows him to go home as quickly as possible. Thank you.
Thank you, Mr. Carnavas. First, Ms. Corner, is there any need to respond?
We don't wish to address your honors again, thank you.
You don't want to address us again.
May I pose a question to Mr. Connolly? Page 24, line 19, you said that the prosecution didn't drop the charge, even though Mr. Kabashi came and tried his best to testify in the Haradinai case. Could you expand on your submission that he tried his best to testify?
Yes. Over a period of 3 days, we appeared in court on Monday, Tuesday, and Wednesday. And Mr. Kabashi was asked a series of questions, which, again, he found himself unable, because of the physical reaction and what have you, to answer them, at least to the satisfaction of the prosecution. I know the prosecutor had many, many more questions to ask, and he was unable to answer them. He did answer enough questions, however, that allowed the prosecution to get his previous testimony from the Limai case, or at least to attempt to get it in. I think the decision is still pending to get it in. And I mention that because it would be false if I were to say that he came and he testified and he gave this glowing testimony, and therefore the prosecution should rethink their position. That's not the case. I think if you look at Mr. Kabashi today, you look at him back when I first met him in Haradinai 1, mentally he still has that inability. I think the problem is that he's never been properly evaluated, and in fact, up until recently, wasn't even aware that there are ways of coping with whatever it is that's bothering him. But he made an attempt. He answered some questions, enough questions for the prosecution to get the transcript in. The defense were offered an opportunity to cross-examine. They chose not to cross-examine Mr. Kabashi. Mr. Kabashi never indicated to the defense that he would not answer any of their questions. But I know that the prosecutor handling the case felt that Mr. Kabashi could have done better. And this is based on 3 days of being in New York, where Mr. Kabashi made himself available to the prosecution to go over his previous statements and the testimony. And even there were some, Mr. Kabashi had made it clear to the prosecution that he was not making any guarantees of how well he would be able to perform in court, although he did guarantee that he would come, that he would abide by the summons, and he came voluntarily.
Any further questions? Anyone? Yes, Judge Morrison has.
Mr. Kabashi, as far as extradition is concerned, perhaps you can assist us to the law which applies. Mr. Kabashi is not a U.S. citizen. He's living in the United States as an asylum seeker.
Yes.
But he would nevertheless be entitled to the provisions of the extradition laws of the United States.
Absolutely.
Yeah.
Yeah. In fact, in order for him to come over here, the Homeland Security Office had to provide him with traveling documents. But he was fully represented by a federal defender.
Yeah.
And we did do some research in this area. The law has changed somewhat. Up until, I would say, a few months ago, the U.S. would not even consider honoring a summons for a witness, although now it has changed. But absolutely, he would be available to all the, just like an American citizen.
So had he chosen to do so, he could have exploited, and I don't use that word pejoratively, I mean it in its other sense, all available avenues under the extradition laws, and I know in the United Kingdom that would take months, if not years, and presumably in the States a similar timescale would have applied.
Exactly, Your Honor, and we did discuss this with Mr. Kabashi. This was an option. The federal defenders in New York are well-funded, well-resourced, excellent lawyers. and they go into court, in federal court, and handle these matters all the time. So it wasn't as if he did not have the proper advice. He was fully aware of that option. And this is why I say it has been a humbling experience, because Mr. Kabashi showed his true character when he said, okay, I know I will be arrested. I will try to give evidence. I know that I've done wrong by walking away when His Honor Judge Ori allowed him to leave the courtroom to come back another day, and never did. So that to me demonstrates, and should demonstrate to you, Your Honors, Mr. Kabashi's character.
Thank you.
Yes. I'd like to add one word, Mr. Carnava, since you refer to it. Of course, walking away is not part of the charges brought against Mr. Carnavas. That should be clear. That's on the record. Then, before I invite Mr. Kabashi and ask him whether there's anything he'd like to add to what you've said already, there's a simple technical matter. Medical reports. You have provided courtesy copies to chamber staff on medical reports, which are over a couple of years. And there is also another, I thought the latest was from 2011. But you also have provided us with a report by Dr. Falke. What's the technical way of putting that on the record? Would you want to have them admitted as evidence relevant for sentencing?
Yes, Your Honor. We did provide a copy to the prosecution. Mr. Kabashi has indicated that he has no objections to it being discussed in the public as well. So if you wish to ask him questions on that.
No, it's mainly a matter
Yes.
on how to have them to be part of the record.
Yes.
And if you would have any spare copies, I would invite Madam Registrar to assign exhibit numbers to them. Yeah. And do you have any spare copies?
I should have. I did provide a spare copy, Your Honor.
Yes. Madam Registrar, did you receive it? We have two. The first is a report by Dr. Falke dated the 31st of August 2011. Madam Registrar, is there a copy available to you?
Yes, Your Honor, I have that report.
Would you please assign a number, and then it would be defense number?
Your Honor, that would then be Exhibit D1.
D1 is admitted into evidence, and from what I understand, Mr. Carnavas, there is no need to have it under seal. Or would you, although we could discuss it in open session, would you nevertheless would like to have this privacy sensitive document under seal?
Yes, Your Honor.
Yes, you have said something about it in open session. Let me just...
Well...
Yes, Mr. Carnavas.
I spoke with Mr. Kabashi. He, as I've indicated, he has no objections to putting it on the Elmo, and you can discuss it with him if you wish. So there's no need to keep it confidential. Okay. I think that the whole point...
Then it is admitted as a public exhibit. Then the small set of medical reports, which you...
That I would ask that those be kept confidential, Your Honor.
Okay, Madam Registrar, have you received a copy of those?
I sent it last week. They should be available.
I'll ask chamber staff whether there's any copy.
I know the
available.
I have a copy if anybody needs it. I didn't need
took mine out.
Madam Registrar, if we admit something into evidence, then of course the registry should know what it was that it was admitted into evidence. And the bench has one spare copy apparently. Madam Registrar, that set of medical information would receive what number?
Your Honor, that would then be Exhibit D2 under seal.
D2 is admitted into evidence under seal. Mr. Kabashi, is there anything you'd like to add to what has been said this afternoon, also in addition to what Mr. Carnevos has told us?
Profile David.
Yes, thank you. Thank you very much for the opportunity you've given me. I believe that everyone understands the situation and everything, but I wanted to apologize to Your Honours and to the Tribunal for the problems that I may have caused starting from 2007. I apologize that I haven't been as useful as I should have been. And contrary to the strong desire that I have to go back to my family, I respect and accept any decision that will be taken by this court in respect of the law. Thank you.
Thank you, Mr. Kabashi. This means that this sentencing hearing is about to be concluded. The Chamber will have to consider all the submissions made by the parties. The Chamber, in that respect, will also consider, as far as timing is concerned, whether a judgment at a later day would be unfair to Mr. Kabashi, because he has spent some time now in detention. At the same time, we still have to consider what sentence we would impose. Now, and I'm very cautious in saying this, I would not exclude for the possibility that sentence would be pronounced later today. But this is not excluding for a possibility, is far away from doing so. We'll consider that. We'll inform the parties as soon as possible. Let me just confer for 1 minute with my colleagues. Because it's all rather vague what I said, we'll take a break, and we'd like to resume in 50 minutes, and most likely we could be more concrete at that moment, as I tried to be a minute ago. We will take a break, and we'll resume at, if that's possible as far as tapes are concerned, at 4:05.
All rise. Please be seated.
The Chamber has considered how to proceed in this case, and we have decided, although it's in need of further verification as far as availability of courtrooms, etc., that we are expecting to issue a scheduling order for the pronouncement of judgment, which would then be on the Friday the 16th of September at 3:30 in the afternoon. But as said before, we have to check all the practicalities of such a scheduling order. The detention order is not lifted, which means that Mr. Kabashi will remain in the undue at least until the 16th. We therefore adjourn and most likely will resume on Friday the 16th of September at 3:30 p.m. Courtroom still to be determined. Mr. Canavas.
Just one clarification. I may not be here. I assume that the court would not object to me participating by video link.
If that would
I'm scheduled
video
to.
link, yes. The only you're excused for not being present, and what would be the most appropriate solution? I mean, there's not much else to do than to hear the judgment being pronounced. So whether you would seek replacement and receive a telephone call immediately afterwards, or whether we could easily set up a video link is again our practicalities. I've got no idea about costs involved, but you are excused. We do understand that you have duties elsewhere, and that we are trying to find a practical solution for your absence, if that would be
Very well.
acceptable. Then we adjourn until that date.
All rise. Fearfully.